Good morning. How are you? Good. Good morning. Welcome to a new week of rules. All right, see we've got a fair contingent over there on the wall. Chairman Houston, what you got?
Thank you, Mr. Chairman. This morning I bring you House Bill 85. House Bill 85 provides a tax exemption for nonprofit organ procurement organizations of Georgia. LifeLink of Georgia is the federally designated organ procurement organization that serves our state.
Are there questions? You have no questions.
Thank you.
Chairman Nix.
Good morning. Thank you, Mr. Chairman. I'd like to ask for House Bill 130. And this bill would allow the Georgia Foundation for Public Education to establish a 501c3 designation to receive contributions. They can receive contributions now, but it's my understanding there are a number of organizations that will not give to an organization unless they have that 501c3 designation by the IRS, and this just allows them to apply for that through the IRS.
You have no question.
Thank you, sir.
Chairman Watson.
Thank you, Mr. Chairman. Members of the committee, bring to you today HB 35. It's the first one under structured rule. This is creating a tax exemption for the poultry diagnostic lab. They are administratively attached to the Department of Agriculture. We appropriate money to them, and then they pay sales tax. So we're trying to fix that for them. So this passed this body 161-2 last session, but got caught up in the Senate. I appreciate your support.
Chairman Martin.
And gentlemen, take a question. You said they are administratively attached to our Department of Agriculture or the U.S. Department?
Our Department of Agriculture.
Thank you. I thought if they were attached federally, they would be tax exempt anyway. That's the reason I asked the question.
No,
Thank you.
sir.
Representative Williams.
Thank you, Mr. Chairman. This is all of the labs. Are we talking about the one particularly at Gainesville?
Yes, sir.
Yes, sir. At some time, I'd like to talk with your committee went out. I'd like to know what you find out, and have you all located the guy who built that trap down there yet?
Yes, sir. No, I have not. I know that there's some people working on that, but this particular bill doesn't have anything to do with the building itself. It has to do with the services that the people within that lab provide, and will help them be able to protect the poultry industry, which is a $38 billion economic impact to our state. Thank you.
You have no more questions.
Thank you, Mr. Chairman. Appreciate your support.
Representative Werkheiser.
Thank you, Chairman. This is not on your sheet. It was passed out Wednesday, a week ago. House Bill 123 moves the State Workforce Development Board back to the Department of Labor. It is not on the blue sheet.
Whip Kelly.
Okay.
Mr. Chairman, just a quick question. How long ago did we put this underneath the technical college system?
Just last year. This has had a tough time finding a home. It was in the Department of Labor. The Governor Deal moved it to the governor's office. Next year moved it to Economic Development. Next year moved it to the technical colleges. And the new administration has asked that it be moved back to the Department of Labor.
If I remember correctly, one reason why we moved it to the technical college system was because our technical college system is more focused on workforce development than maybe just keeping up with the statistics of unemployment like our labor department does. And so I hope we have a chance to talk some more about this, some serious reservations about moving it back after 1 year.
Totally understand. Thank you.
You have no more questions. Chairman Silcox.
Thank you, Mr. Chairman. I bring to you this morning again House Bill 158, which is going to allow Medicaid recipients as well as those in the ADAP program to be on the same formulary for HIV drugs. It will require a single tablet regimen, which is less expensive and more effective for the state. Would welcome any questions.
You have no questions.
Thank you.
Representative Prince.
Thank you, Mr. Chairman, committee members. I present House Bill 64. It's in a modified structure about halfway down. What House Bill 64 would do is require that a child that is alleged of child abuse during DFAT's investigation, as they are doing the investigation of the child, to find out if the parent or the guardian is on active duty in the United States military. If that is true, then DFACs will be required to contact the Family Advocacy Center or that military installation which that active duty member is a part of. This is to close the coordination between the federal as well as the state.
So tell us what is, as I see it, you've got 2 points. Number one, try to make the determination, and number two, inform. And what does this do as far as either help the situation, help the child?
Well, what it does for the child, and that's the focus here. Matter of fact, that's the title. It's called Protecting the Military Child, is to make sure that when that child of an active duty parent goes from station to station, post to post, that the federal government can also continue to track that. Because see, DFAS, once they leave the state of Georgia, they'll sort of pass that case on, but at least the military has eyes on over there.
Any other questions? Representative Williams.
Thank you, Mr. Chairman. And thank you for bringing this bill. Is it not true that the military handles child abuse cases quickly, definitively, and it's done?
That is correct, as well as just wanted to make sure that they can provide extra resources or their resources if needed to the state. Again, it'd be a state issue, but additional resources that the military can provide, they're there to do that as well.
Chairman Cooper.
Okay, so if I understand correctly, once they're notified, the feds don't take over the investigation. They leave it to the state, but they just act as helping the state in their investigation.
Yes, ma'am.
But the state's in charge.
The state is in charge, yes,
Okay,
ma'am.
thank
Again,
you.
yes, ma'am.
Okay. You have no other questions?
Thank you.
Representative Turner.
Thank you, Chairman. Members of the committee, I bring before you House Bill 42. It is the fourth one down under modified structure. This is the bill that would remove the state's authority to revoke a professional license because of default or people getting behind on their student loan debt.
Chairman Fleming.
Thank you, Mr. Chairman. Representative, and I'm trying to look through the language right now. It says the commissioner shall not suspend, and then it goes on to talk about someone who's in default. So if I'm in default, and I hadn't read the language, so the question I have is if I'm in default but I have another problem, does your bill prevent me from being suspended for that other problem? Because it says right here, all I have to do is have a defaulted student loan and I can't be suspended.
I'm not sure I follow the question.
I got two problems.
Okay.
I got a defaulted student loan, and then I violated some standard of my profession, which would normally have had me
This is
revoked.
strictly, so if you go through the language of the bill, it applies directly to the language for student loans, specifically per profession. And then there is a code section that basically says if a student loan default is not going to be the reason why you lose access to a professional license.
Is that in this bill?
Yes, sir.
What line?
I don't have it in front of me, sir, but the bill is some 40 addresses.
It's very long.
17 different professions. The reason why it is long is because there are professions that are named specifically that we have to go through and strike that language for each individual profession. And then we added a section for any profession that might do this through rules and regulations as opposed to in the code.
But you understand my question. And
I do,
you can
but
get with me offline and to show me how that's
Sure.
not the case. Thank you. I appreciate it.
So you're going to circle up offline?
Yes, sir.
Okay. No more questions. Representative Jones.
Thank you.
Thank you, Mr. Chair and members of the committee. I'm coming forward with a very simple housekeeping bill that deals with several lower court rulings as well as 2 Supreme Court rulings, and that is private organizations cannot make appointments to various boards. The first, House Bill 24. House Bill 24. In '79, there was a Supreme Court case, Mag versus Rogers, where it talked about Medical Association of Georgia making an appointment to a board. And that case was litigated, and it was ruled that it was unconstitutional, again, primarily because it was a private organization. Also, more recently in 2018, there was another court ruling, DeLay versus Sutton, which Supreme Court upheld that, and again, by unanimous consent, said that private organizations cannot make appointments to various boards. And if you may not have a copy of the ruling, but it specifically wrote, Justice Melton, the Chief Justice specifically wrote that the General Assembly may, within its constitutional limitations, establish qualifications for a public office and designate a governmental appointing authority, but it cannot delegate the appointive power to a private organization. Such an organization, no matter how responsible it is not in the public domain and is not accountable to the people of our Constitution, which requires. This is a violative of our Constitution. This was, again, just recently in 2018 by our Supreme Court. There was an issue on this that came up, or a question, Representative Fleming in the committee, about does this have an impact on grand jurors? Well, it does not, because jurors are summoned by the clerk of court, which is an elected official. So there were no issues with that, although it was amended, and I accepted that a friendly amendment to include grand jurors, that it did not exclude grand jurors, I should say. And so, Mr. Chairman, that's pretty much the genesis of the bill.
You have no other questions? Wait. Chairman Fleming, did you have a question?
Please, Mr. Chairman. Representative Jones, I appreciate you working with us in committee, as you just mentioned on this bill. And I told you beforehand I was going to ask you this question. So. You are correct. When we sat in committee, and I did have to leave before final passage to go to another committee, we brainstormed, okay, the concept is sound. I agree with the concept. Are there going to be any unintended consequences was the question, and that's why we added grand juries, because as we sat there, we realized that grand juries make appointments, but they're not elected. And I heard your explanation. So my question is very simple. You're going to guarantee us there are no more unintended consequences from this bill going forward, correct? Simple question.
If you support my bill, I guarantee it.
Okay, good. Thank you. I appreciate that.
You have no other questions?
Thank you, Mr. Chairman. Thank you, Representative Fleming.
Chairman Green.
Thank you, Mr. Chairman. I bring two bills, House resolutions to the committee. House Resolution 165, which is our conveyance and lease of state-owned properties. And you have a list of those individuals that I've passed out to the committee that involve Chatham, Clayton, Colquitt, Forsyth, Hall, and Monroe County. This is our annual resolution.
You have no question.
And the other one is House Resolution 182, which is the granting of easements over our state-owned properties, and the list of those counties are made available to the committee as well.
You have no questions.
Thank you.
Chairman Dempsey.
Yes, I bring to you two bills. The first is HB 160, dealing with bariatric procedures, trying to reinstate that pilot program again that we did in 14, but did not make it to its final passage last year. The second bill is HB 187, which is also a pilot program for coverage for medication to deal with overweight, obesity challenges.
You have no questions. Chairman Stevens.
Thank you, Mr. Chairman. I bring you House Bill 186, which takes care of a problem we've got in Savannah, primarily that has a public hospital being sold to a private hospital. The proceeds could then be used for indigent care other than only hospital care. And this is in the case of Memorial being sold.
You have no questions. Chairman Powell.
I'd like to ask for House Bill 192 under modified structured. This puts the GREC, the Georgia Real Estate and Appraisers Board, in compliance with the federal regulations for the appraisal management companies. These are the folks that do the appraisals for banks, and they come under high scrutiny of the federal government if they're doing loans.
Chairman Fleming.
A question to Chairman Powell, if I may. Chairman Powell, I think I understood your explanation. It simply brings the entities you mentioned into compliance with some new federal regulations, but makes no other changes under Georgia law?
No, you're absolutely right.
Okay,
The
thank you.
appraisal management companies are the intermediaries between licensed appraisers and the federal government that if they're doing these loans.
Okay, thank you, sir.
Chairman Harrell.
Thank you, Mr. Chairman. House Bill 183 under structured rule. This simply protects the property owner's right to file an appeal on their property tax assessment. Current law requires or provides that property owners may return their property between January 1 and April 1. If failure to return the property, the prior year's value is deemed returned. We've had a few tax assessors take the position that if a property owner does not file a return each year, they have forego their right to file an appeal. This simply reinforces current statute that the property owner has the right to file an appeal. Would you like me to mention 182 as well?
Yeah.
House Bill 182 lowers last year we passed House Bill 61 that begins sales tax collection for online retailers. This is tax that has always been due but has not always been collected. Subsequent to that, there was a U.S. Supreme Court decision that lowered the threshold from $250,000 in sales within the state of Georgia, which House Bill 61 addresses, to $100,000 in annual sales within the state of Georgia. House Bill 182 simply adopts that lower threshold as established by the U.S. Supreme Court.
Chairman Fleming.
Thank you, Mr. Chairman. Chairman Harrell, on the first one you mentioned, House Bill 183, that deals with the return of property and assessors. I know the Property Assessors Association have folks that look over these bills, and my assumption is you work with them and they're fine with the language and how it's going to operate.
My understanding is, as is so often the case, there are normally just a few actors that don't always understand the clear language in our current statutes, and that appears to be the case here. The vast majority of assessors understand the statute as it is currently written, and to the best of my knowledge, have no objection to the clarification here.
Thank you, sir.
Chairman Efestration.
Thank you, Mr. Chairman. Chairman Harrell, on House Bill 182, in your committee, was it determined or was there testimony about how many additional businesses or sales would be captured if 182 were to pass?
Yes, sir, and there is a fiscal note on House Bill 182. It indicates that the additional retailers that would be captured is somewhere in the neighborhood of 5% or less, and additional retailers. The total anticipated additional revenue, both state and local, is approximately $20 million a year combined.
Chairman Martin.
Chairman Harrell, this is something we've talked about before, but just wanted to ask you again today is we're moving this, is it not true, to $100,000 because that's what in the Wayfair case was one of the 4 tenants they ruled on, correct?
Yes, sir.
It isn't also true that just something for the committee to consider, and we have spoken about that one of the tenants in the Wayfair case was that this was constitutional as imposed by South Dakota because they right-sized the collection amount at $100,000, and that was in South Dakota for a state of somewhere around 1 million people. I do have concerns that by moving it to $100,000 for a state that has 11 million people, we perhaps are opening Georgia up, is not true, for litigation. I realize California and other states have also done this, but should someone decide to litigate, there could be an issue. I bring that again as a concern. We want to make sure that we don't lose the opportunity to do what we're doing now.
I guess, we're always subject to litigation on everything we do. That said, I think we're up to 23 to 25 states around the country that are adopting that same standard and moving to the 100,000. Keep in mind, that is $100,000 a year in sales that are delivered within the state of Georgia. So if you're a retailer outside of the state of Georgia and you're delivering into Georgia $100,000 a year at a minimum sales, we're probably not your only customer. You're probably doing business in a number of other states as well. So this is more often than not, this is not what most of us would think of as a small retailer, a small business. If you're doing $100,000 a year in sales in Georgia, you're probably doing a similar amount in a dozen other states as well. So it's a business of a fairly decent size.
No more questions. I'm going to ask Chairman Hatchett, if he will, to preside while I present a bill.
Matt, move over.
That's the hardest part. Chairman Powell, do you have a bill that we might have heard before over the last few years?
I do. This is House Resolution 164. It's a proposed constitutional amendment. Anybody that's been here for any period of time knows that it's been a passion of mine that we spend money where we tell the voters that we are going to spend money. And if we collect $1 for recycling tires, then that's what we ought to spend that dollar on. And we haven't been doing that, and haven't been doing it for at least the last 10 or 12 years. And what this is it's a constitutional amendment that will allow this legislature to statutorily dedicate fees. Right now, we can either dedicate them in the Constitution or we can dedicate them by statute, but the statute is not binding on future legislatures and is not binding on the appropriation process. What this would do is put an intermediate level in there so that it is constitutional for the legislature to dedicate fees, and it's got several safeguards. First of all, any bill that is passed that is to dedicate fees, that if it's going to get this constitutional provision, it has to refer in the bill to this, that it's being enacted pursuant to this constitutional provision, has to pass by a supermajority. It cannot, it has to sunset in 10 years or less. We cannot statutorily dedicate more than 1% of the previous year's budget or expenditures. So for instance, if this year's budget is $27 billion, then we would be limited to $270 million in the amount that we could dedicate. So it keeps us from over-dedicating so that we do not have the ability to perform essential functions of the legislature. It also provides that in the event of fiscal emergency or financial emergency, that both bodies, both houses can by resolution suspend the enforcement of this, so that if we do need to make a choice between dedicated fees and paying teachers, that we can make that choice. So it's got a lot of flexibility, but it will provide a mechanism that when we say we're going to do something and we represent to the voters that you pay this fee and it'll be used for that purpose, that we can then enforce that. I'd be happy to answer any questions.
Looks like you actually do have a question. Representative Williams.
Thank you, Mr. Chairman. Mr. Chair, I didn't want you to sit without at least one question. I've almost learned this bill by heart. And my question is, the average Georgian thinks that we spend their money like we tell them we are going to anyhow. What's the biggest deterrent to this bill? Why can't we pass what seems like a no-brainer? What's the pitfalls that keep requiring you to bring it year after year?
There are those who want the unfettered flexibility to budget how they want to see budgeted, and they don't want their hands tied. And the way that the budget process works is that we are presented with a budget, and even if we see that solid waste trust funds are being spent for a purpose other than what has been intended, there's not a way to fix it without fixing it at the subcommittee level. And so, you know, we go along with it, but this will keep that from happening.
Chairman Tanner.
Thank you, Mr. Chair. First of all, I want to say this is, I appreciate you working on this. This is a big issue that I hear a lot about from constituents. But one question, in House Bill 170, we wrote language in the legislation for some of the fees that if it was not appropriated for that purpose, those fees would go away. This wouldn't have any effect on that, would it?
In my opinion, no. But for a little bit of history on this, my original legislation was a statute that said, or a bill that said, if you do not spend it for its intended purpose, that the fee will be reduced. And that language in 170 was actually taken from my original bill. We put that language in the Solid Waste Trust Fund renewal and the Hazardous Waste Trust Fund renewal. When Governor Deal signed that legislation, he also issued a signing statement saying that he did not believe those restrictions were constitutional. And so if he took that position on hazardous waste and solid waste, then obviously he would take that same position on the provisions that are in 170, which is why then Andy Welch and I got together and did this constitutional so that there wouldn't be any question that it's constitutional because it'd be written in the Constitution.
Thank you.
No more questions. Can I set the calendar? No, I'm just kidding. I just got fired.
That's the only bill I have, so that's the last chance he's going to get to chair this meeting. Are there any other members that have bills to present? Chairman Cooper.
Mr. Chairman, is it all right to put our names by certain bills?
Pardon me?
Is it all right for us to, at this point, put our names by certain bills? To ask for them, that they've already been asked for?
Are you got any on this?
Yes, sir.
Okay.
Okay. First of all, I would like to advocate for House Bill 158. That's where we would have Medicaid have the same program for HIV medications. If you've watched the news lately or heard the president's speech, we are one of 4 states that are in dire need and have the highest HIV deaths and new cases. Cobb County alone had 4,000. And one of the ways of controlling this, which the president says we're going to eradicate in 10 years, is to make sure patients take their medicines. And so this bill is extremely important to move toward that goal. So that was House Bill 186, and then House Bill 42. Just like we revised our way we treat offenders with minor offense that are nonviolent, and we've changed those laws. The old law that we did where we took away licenses, when people can't work, they can't pay anything and often go on state assistance. So if you take away somebody's license to work because they haven't paid their student loan, you're really handicapping them. And the bill allows for all other kinds of measures, of collecting debts, but it really is important that we change that, sir. Thank you.
Thank you. Chairman Powell.
I'd like to put my name beside H.R. 164, not just because the author is a close, distant kin of mine, but because of the nature. And I would certainly recommend everybody do so in unanimous consent on this bill. But because of this, the language in this bill is something that's long overdue. While the distinguished chairman mentioned a few of the cases, goes back in 2004 when we passed the Joshua's Act. There was over $100 million that was levied on the backs of fines, and it went into the general fund instead of going where it was supposed to be going, and that's to driver education courses. Since that time, that 5% rate had been dropped over quite a tussle a few years when it was renewed. We dropped it back to 1.5% onto that. So great bill.
Okay, I see no other members. We're going to set the calendar for today, and we're going to set the calendar for tomorrow. Today's calendar will be relatively short because we've got the state of the judiciary today, and so we don't want to extend it too far. For today's calendar, House Bill 158. It's on. House Bill 192. It's on. And that will complete today's calendar. Now we're going to set the calendar for tomorrow. H.R. 165. It's on. H.R. 182. It's on. HB 35. It's on. And then the dark horse candidate, H.R. 164.
Move. I think we need a vote.
A roll call vote.
It's on, and we are adjourned.